is what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified?
Still with us in Phoenix, Arizona, former criminal defense attorney who represented Jodi Arias, Kirk Nurmi, and now I'd like to also welcome in Orlando, Florida, criminal defense attorney Mark O'Mara, who represented George Zimmerman. And I've got all the famous phenomenal criminal defense attorneys on with me today, gentlemen, which I'm very appreciative of, because first of all, I'd like your preliminary thoughts on 5:20 on a Friday afternoon after a long week of listening to testimony, very long closing arguments today, and the jury is now receiving these jury instructions, knowing that although they can stay as late as they need to reach a verdict, there's a lot to go through. What do you think about this logistical aspect of it, Mark?
You know, there's arguments on both sides, I guess, but my concern is, like you say, a week's worth of testimony, closing arguments, which the lawyers love, but sometimes can be a little bit boring for the jurors. But more importantly, if they have fatigue, how is that fatigue going to enter into their deliberations? I think that they should have probably stopped when they did after closing arguments, but come back tomorrow on a Saturday just to keep the progress moving. Give the jury instructions then, let them get a fresh start on deliberation. That gives them most of a day, which is a good lengthy period of time to do it. And then, yes, they can plan if they need to be sequestered over Saturday night. But doing it tonight, I think, is dangerous because of the fatigue. However, judges have great discretion, as you know, Ashley, to do it the way they want to do it.
Yep. And the reality is, I must point this out, because when I was on the bench, of course, this trial at this moment in time is the most important thing to the judge. However, every judge has a busy docket, lots of other trials, and we don't know when her next trial is scheduled to start. It doesn't mean that she's going to forego justice, but it was always a balancing act. Logistics in terms of getting trials on the calendar, getting them heard, finishing, getting to the next one, I think for a judge is a really tall order sometimes. Kirk, problematic or not that this jury will begin deliberating late in the afternoon on a Friday evening?
Well, we don't know that they will. I mean, they could go back and just decide that they're not going to go beyond the day, that they are too exhausted, as Mark pointed out, because they heard hours of closing arguments. Now they're hearing jury instructions. So it's quite possible that they've had enough. Maybe they want to think about it before they go into deliberations. They could take a preliminary vote to see where they're at, see if they think there's any chance of resolving it this evening, because jurors aren't going to want to be sequestered. Jurors aren't going to want to work on the weekends. I guess working on the weekends is now something that happens in the COVID era, but, you know, the logistics of opening the building and everything used to be prohibitive for that sort of thing. So maybe they'll want to work the weekend. Maybe they'll take an assessment. It's just hard to say how the jury feels individually and collectively what kind of progress they can make given their most likely exhausted state of affairs.
And you know, we know from trying cases, and I know from being on the bench, that juries handle it differently when they go back in that deliberation room and what they do first. Sometimes you hear after you talk to jurors that the first thing they did was take that preliminary vote to then decide where to go from there. Some said, no, we want to talk about everything before we take a vote. I'm so curious because I have each of you that represented very high-profile defendants, high-profile cases. So Kirk, let me start with you, Jodi Arias. Did you get an opportunity to speak to any of the jurors afterwards to find out how they started when they went back there to deliberate?
Boy, it was a long time afterwards. I think everybody needed a cooling off period, but I did have that opportunity to do that with, you know, particular jurors that connected, and I won't go into those discussions for probably obvious reasons, but that was always a good thing, not only in terms of deliberations, but, you know, Miss Arias, we had a death penalty was on the table, and we had a second trial at hand. So I was grateful for that opportunity, but it depends on the disposition of each individual juror. And, you know, keep in mind the Arias case was like a 5-month-long trial, so they probably had enough of hearing from me for quite some time and needed a rest.
And that's fair. It's a long trial, 5 months, and I know in this trial we've been here for a week. Still a long time, but not the same as one that goes for months and months. And Mark, you had an acquittal in your case. After an acquittal, do you even want the opportunity to speak to jurors, or is it more of like, nope, not saying a word, I'm out because I just got an acquittal for my defendant and there's nothing more that needs to be said?
Right, you sort of want to grab your trial bag and just go home. But in that case, we were reached out to by 3 separate jurors, 3 separate occasions that really wanted to talk to us about it. Part of the reason why is because there was some publicity after the fact, and people were saying that something different happened in the jury room. So there's a lot of that going on. But yes, I really enjoy win, lose, or draw. You like talking to the jurors because those are the ones, you always want to be a fly on the wall. And we did get some good insight, and they did what I think they should have done, which is don't they take that preliminary vote. I don't like that because that just starts all of a sudden maybe separating the people, right, putting them off in the corners. So what they did was what I think they should do: pick the jury, 4-person, and then sort of move forward. Let's let everyone give their quick idea, and then let's get into the evidence. And that's a more deliberative way to handle it than just starting out with that first vote, because sometimes when people say something, they stick to it, and that can be dangerous.
Yeah, it's such great insight. Thank you both for offering that, letting me put you on the spot unexpectedly to both of you, because it gives us all and our viewers real insight into what can happen back in that room that is confidential, that nobody knows about, nobody's allowed, it's not recorded, but you all have just shared some great insight. Thank you for that. Court TV